Good morning, everyone. Pleasure to be here. And I want to thank Roger for inviting me. When Roger calls, I always say, yes, I'll certainly help you out. But I want to thank somebody else who is not here, but he actually helped me, and his name is Victor Nitti, a urologist with NYU who actually helped me in preparing this lecture as well. So what I'd like to do today is I want to talk to you about a number of things. I've been asked to speak about the litigation nightmare. I suppose that's been the title of the talk that I have. And when I think about the litigation nightmare, I suppose the way to look at it is a litigation nightmare, but from whose perspective? So I suppose there are really three perspectives that you can look at the litigation nightmare. I am a plaintiff's lawyer. I actually represent those that have been injured through medical malpractice or product liability, general negligence cases. And I also teach, as Roger mentioned. But when we think about it, litigation nightmare, I suppose for the clients that I've represented that have been injured through mesh products, for them it really is a nightmare. For them, they're suffering lifelong injury as a result of something that we say never should have happened. But when we look at the nightmare also, what about the doctors? What about the surgeons that have been involved in litigation? And whether or not they should have ever been brought into litigation in the first instance. And I know you, coming at it as a urologist or a urogynecologist, the question is, how do you stay out of court in the first instance, or how do you get out of court in the event that you have been sued? And I want to talk to you about those things as well. But for you, the concern that I have and why it's a nightmare is, it's not so much, and I know this is going to sound strange to you, it's not so much that the plaintiff's lawyer is faulting you. In a lot of the mesh cases you're going to see, I'll demonstrate this in a little while, it is actually the product manufacturer that is actually faulting the doctors, faulting the surgeons for what they've done. And as far as litigation nightmare, well, when you see the numbers, certainly for the product manufacturer, it has been a nightmare for them as well, knowing the number of cases that have been brought. So when we think about the product, what's happening here, I couldn't resist this one when we saw what was happening. So let's take a look at what really has happened. You take a look at the number of cases that have been filed, and the number of cases that have been filed is enormous. It is second only to the asbestos cases that have been brought. And you think about it, why are there so many cases? What happened with respect to this? And why now, all of a sudden, within the last month, have there been so many suspensions on the mesh products? Why, for example, have they been banned in England? Why are they actually banned altogether or suspended in Australia, in New Zealand, Northern Ireland, Wales? What happened that made them do this? Well, I want to talk to you about some of the things that have happened, but I also want to show you what really takes place in court. And I think you need to see what really happens in court. So one of the things that you never, ever get to see is what really takes place. What are the lawyers talking about in court? And what happens with respect to the mesh products? So I thought one of the things that would be interesting for you is if I actually presented an opening statement in a case, an actual mesh case that was tried, in fact, right here in this state. And this way you could see exactly what did take place, and you could see why it is that there are two types of damages that are being awarded, not just compensatory damages, but punitive damages when you see the conduct underlying the very product that we'll be talking about. So I'll take you back a couple of years, and I'll talk to you about a product known as the ProLift, which was used in vaginal mesh surgeries. Why don't I just start the opening statement, you'll see the way that it goes through, and you'll actually see what happens in court. May it please the court, counsel, members of this rather large jury. I have the pleasure of representing a woman who has been injured. Her name is Patricia Smith, and she went for surgery back in May of 2009. At the time she went for surgery, she trusted her doctor by the name of Baker, and I want you to know right now, we do not fault the doctor at all for what happened here. She trusted that doctor, but what she didn't know and what she couldn't have known is that the product that was about to be inserted into her for something known as pelvic organ prolapse, for stress urinary incontinence, which is really a misnomer. It should be called activity stress incontinence or activity incontinence. What happened was she had no idea that when she had that surgery that in fact it would result in a nightmare for her, that she would never again have sexual relations like she had before this. She had no idea that she would have voiding problems for the rest of her life. She had no idea that she would have pain every time she walked or when she sat. She had no idea that when the doctors tried to remove the mesh product from her, that they would be unable to remove it because it actually eroded through her vagina and actually into the bladder wall itself. Although she didn't know this, I will tell you right now that the product manufacturer knew this well before that surgery ever took place. And they knew it years before, but they kept quiet, and they didn't let her know. And more importantly, they didn't let the doctor know who was going to be placing this mesh product. They didn't let the doctor know of these risks. Yes, they told the doctor of certain risks and made it seem to him like these risks were transient. There'd be a little bit of inflammation, things would go away, things would get better, but that was not the case at all. So what happened was the doctor spoke with his patient. This doctor, by the name of Baker, spoke with Patricia Smith and told her that he believed he could help her. He suggested to her that a device known as the ProLift would be better for her, that it would actually help her out, that it would be better than conservative treatment, but it was anything but. And she should never have had this product installed. She should never have had this product inserted into her in this most precious area of her body. But here's what took place. She sees her doctor. She actually goes for the surgery. Her doctor counsels her, informs her of the risks that he knew about, but he didn't know of all of the risks, and he wasn't told of these risks. He had no idea what the company knew at a certain point in time, well before this ever took place. She goes for the surgery, and she comes out of the surgery. And when she comes out, she's in pain. The doctor assures her and reassures her, it's only transient, things will get better. But the problem is it's now on a downward slope, a downward spiral continuing to get worse. She's unable to engage in sexual relations. She has pain while she's walking. She's having difficulty in avoiding something she never had beforehand, because before this, the only thing that was troubling her was when she sneezed or coughed, she would leak a little bit. Now it's a completely different event that's taking place. Now she's having pain like she has never had before. She goes back to her doctor, and her doctor says to her, there are certain things we can do. We can actually try. We can try and remove the product. And they actually bring her in for surgery. And it was then that the doctor learned he could not remove the product, that it actually eroded through the walls of certain tissue in her body. And although they tried to remove it on multiple occasions through multiple surgeries, they were unable to remove this product. And I can assure you of this, had that doctor known that he was unable to remove the product, had he known that it would have caused lifelong dyspareunia, lifelong inability to have sexual relations, lifelong voiding problems, he never, ever would have used this product. Now, it's one thing for me to stand up here and tell you why it is that we say that this company known as Ethicon, a division of Johnson & Johnson, knew what was going on. They knew the product was dangerous. They knew that they never should have actually allowed this product to go on the market, but they did for certain reasons. And I'll tell you right now, the reason that they did this can be boiled down to one sentence. And that one sentence is profit over patient care. Profit over patient care, that's what was taking place. They were in a rush to get this product to the market, to beat a company called AMS to the market so that they could make profit. Well, there's another sentence that's appropriate in this case. And the other sentence that's appropriate in this case is the life sentence that Patricia Smith now faces as a result of this product, which was poorly designed, which was not one that was given proper warnings to the doctor or to the patient, and certainly one that should never have gone on the market without appropriate testing for the long term. They rushed it to the market. And while I can stand here and tell you about this, I want to show you actual exhibits that we'll be offering in evidence at this trial so you can see why we're saying this never, ever should have taken place. This never should have happened, and it was wrong for this product to be put on the market, to actually be used for women. When it was not properly tested, warnings were not given, and the warnings that were given were insufficient. Here's what happens. Patricia Smith goes to her doctor, Dr. Baker. He wants to help her. He provides her with a pamphlet, and in the pamphlet it actually says to her, get the facts and be informed. It would be nice if they actually informed the patient. It would be nicer if they informed the surgeon. But the company made a conscious decision not to inform the patient or the surgeon, so that the surgeon couldn't give proper advice, proper counseling to his patient. Sure enough, if you take a look at it, that brochure was a beautiful thing. It looked so easy, something that was comforting to the patients who would actually see this. And this is the exact brochure for the ProLift that was installed. The good news, you don't have to suffer with it. You can actually have this product installed. They made it seem like it would work. They made it seem like there were limited risks or minimal risks. But indeed, they knew that there were more risks than they wanted to let out. Here's what happens. They said it was a supportive soft mesh. We will bring forth an expert in this courtroom to actually show you that it was not supportive. If anything, we're going to prove it was not soft. It was firm. It was rigid. That, in fact, it would actually contract. That it would actually deform her vagina for life. That, in fact, she would not be able to have sexual relations, sexual intercourse again. Not just trying, she would not be able to have sexual intercourse again. And what she didn't know and couldn't have known, because no one told her, is that her husband would also have pain even trying to have sexual relations. The brochure, what are the risks? They actually said, although rare. What happens when a company knows that the risks are not rare, but they publish that it is rare? This is something that you as the jury are going to have to decide. You'll have to decide if that was right, if that was appropriate, if that is something that you want to accept. And then we go further. Small risk of mesh material being exposed. A small risk? Wait till you see the numbers and the frequency, and then you'll see why it is that we say this type of advertising, this type of warning was insufficient, this type of warning was, simply put, reckless. Here are the very people who developed the product. Axel Arnaud was developed earlier, and he was the scientific director. He was aware, well before this surgery ever took place, he was aware that there were problems with stiffness of the mesh. He was aware of problems with dyspareunia, problems with sexual intercourse. He was aware of shrinkage, erosion. He was aware of fibrosis. He knew, because a doctor by the name of Jacotin had actually explained to him that 19.6% of his patients were complaining about shrinkage, complaining about an inability to engage in sexual relations. 19.6% of his patients. That's basically 1 of 5 of the patients. But they suggest it's a minimal risk. This man has actually testified that if 2% of his patients complained of this, that the product would not be safe for the market. But he knew about this. They knew about this. And in fact, although they knew about this, they weren't sharing it with others. And then they come forward and say the product is safe. Anything but safe. Scott Sierocca. He's actually research and development for Ethicon, the division of Johnson & Johnson. And he knows that there was an urgency to get this product to the market, an urgency because they wanted to be first. They didn't want AMS beating them out. Profit over patient safety once again. And certainly he knew that there was no appropriate study that was done to remove the mesh to see whether it could be removed safely if in fact it didn't work. Well, it can't be removed safely. And it was not able to be removed safely, and it caused pain, additional unnecessary surgeries. David Robinson. David Robinson was the medical director, and he actually knew that the vagina was not the same as the abdomen because they had been using this type of product in abdominal hernia surgeries beforehand. Well, the product was not the same. It needed further testing, and he knew it needed further testing. But what I'm about to show you right now is something that I want you to consider very carefully. Because throughout the course of this litigation, we actually had the ability, in something known as discovery, before we even come to trial, to take a look at the documents, to take a look at what they knew, to take a look at what Ethicon knew, and what they did not share. And when you see this, I want you to understand we're presenting this to you so you can fully and fairly evaluate the facts. And here's what you'll learn. There was an email sent by that very man, David Robinson. And this is what he wrote in October of 2005, well before this surgery ever took place in May of 2009. I'm aware of 4 cases of total prolifts done in folks with normal pre-op voiding, who then post-prolif can't void. Now, he had a choice at this point in time. This man had a choice at this point in time, and the choice was this: to either notify, to tell people, to explain to people that there's a problem, to tell the various doctors who are going to be doing the surgery, there's a problem. Your patients might not be able to void afterwards. So the choice was to either volunteer this information or to seal their lips, zip it, keep quiet, not say one word about it. Not say one word about it and keep the doctors in the dark. and of course, keep the patients in the dark. This is what his email reads. If this starts getting reported, it's going to scare the daylights out of docs. This was written in 2005. A document like this where they know it's going to scare the daylights out of docs and they don't tell the docs? They made a conscious decision not to tell. They made a conscious decision to hide this information, to prevent the doctors from finding out what was going on, yet they put this on the market without ever sharing this information. And then you have a patient, Patricia Smith, who has been so badly injured by this. This isn't just negligent conduct. This is reckless conduct bordering on intentional conduct. Gene Kemmerer. Gene Kemmerer is a man who was an engineer, and he knew that they had concerns about meth shrinkage back in 2004. They had concerns about this, but they didn't share it with anyone. They didn't let the doctors know, and certainly they didn't let the patients know, and that's completely inappropriate. James Hart, a medical operations man for Ethicon. He didn't think clinical research was needed because it worked in the abdomen. Well, the vagina is very different. It has an elasticity to it that's much different than what would be found in the abdomen. And in fact, it wasn't tested properly. But he also knew that this mesh would be very difficult to remove. And they made a conscious decision, once again, not to share this information with the very surgeons that would be actually implanting the mesh. So once again, they're keeping things quiet. And then we get to Charlotte Owens. Charlotte Owens is the Global Medical Director for Ethicon. And she was charged with the responsibility of preparing something known as a clinical expert report on this very product. When I tell you what's about to happen, what actually happened with her, what she actually did and what she didn't do, you'll see why we say that what this company did was reckless. Charlotte Owens actually was aware of some of the risks. She was aware that there were long-term complications. She was charged with the responsibility of preparing a clinical expert report, and what she did was this. She actually took from another report, she cut and pasted portions of another report into this clinical expert report and passed it off as if it was legitimate. If a child did that, if a 12-year-old child did that in school, cut and pasted and submitted a report to the teacher would fail the student. But we're not dealing with a test. We're dealing with human life. Human life like our client, Patricia Smith. And this is what happened. So I want to show you some more emails just so you can understand the gravity of what we're saying here. This is one that was actually sent to Patricia Smith. So let me zoom in so you can actually see. When you see a document that actually reads at the very top of it, please shred these two documents. Shred these two documents? They're really suggesting that documents should be shred? And that's what they're doing without ever telling the surgeon? I've reviewed the clinical expert report and have significant concerns about it. Let's shred this document. Let's make sure that our lips are sealed. Let's make sure that no one finds out about it. Well, there's a problem with emails, and we all know what the problem with emails is. The problem with emails is they never go away. And because they never go away, we now have this to show you what they wanted shredded. It's not shredded. It's for your evaluation so you could see the conduct underlying this is something that never, ever should have taken place. And you, the jury, have to determine what's appropriate here. So what happens? They produce a document, something known as the instructions for use. The instructions for use where they're going to tell the doctors what they need to know about the product. And the question is this: should they come clean and tell the doctors before they insert this product what the risks really are? Here's what they did not share with the doctors in their instructions for use: the permanency of the risks, the frequency of the risks, the difficulty with removal of the product. Don't you think the doctors would want to know this before inserting this product? How about the chronic pain? How about the repeated erosions? How about the multiple surgeries that would be needed to take this product out, and that they couldn't even take the entire product out? And then what happens is you have a doctor who didn't know these things, and we are not faulting the doctor at all, but although we're not faulting the doctor, Ethicon, Johnson & Johnson is faulting the doctor. And what they're saying is this is a doctor who did not have the competence, the ability to actually perform these surgeries. So they're turning around and they're blaming the doctor for what took place, saying that the product was bunched up because of your inabilities. Let's see what the doctor would have to say. This is actually from the doctor's deposition, from Dr. Baker. Did he know about painful sexual intercourse? The answer is no. This is actual testimony from his deposition, and if he echoes what he said at deposition, I'm telling you right now, this is what he will say. If he had learned about this, would he have used the product? The answer is no. He would not have used the product. How about contraction of mesh? Did he know about that? Absolutely not. Would he have used the product? No, he wouldn't have. It would have been a red flag to him. Mesh removal? He certainly wasn't told about that. That would have been a red flag for him. If he had been told that, he would not have used the product, but he was not told that. He was kept in the dark. In fact, they kept their mouths closed about this so that the product would be used, profit over patient care, and a life sentence for a patient. How about knowledge of risks to the patient? He would not have offered it had he known of these risks. He would not have offered it had he known that it was even close to this. How about contraction and pain? He didn't know about that either. And here's what happens. He would not have used this. He would not have used that product had he known of all of these risks. And in fact, he would not have even offered ProLift. So it boils down to this, members of the jury. There was a product that was put on the market, profit over patient care. You have to determine whether or not this was appropriate, to actually know of the risks, to know of the pain that would take place, to know that patients were actually suffering with this. We have asked for two types of damages in this case. The first is compensatory damages, damages designed to actually compensate the patient, compensate the plaintiff, so that she could actually be compensated for the lifetime of pain that she will have. And she's a woman who's in her early 50s. She will live at least another 30 years according to the actuarial tables, and maybe longer. But for that time, for those 30 years, every single day of her life she will suffer. And for that, we will ask for compensatory damages. But there is another type of damages that we will be asking for, and that's known as exemplary damages or punitive damages. When a company knows about dangers and they make a conscious decision, they elect not to share that with the patient and certainly not to share it with the doctors, that is wrong. That is something that never should have taken place, but it did take place. And because that took place, we're asking you, as the members of our jury, to set an example and to say to other companies out there, don't even think about doing this, because if you do, we're going to award punitive damages, to set an example, exemplary damages, to say this will not happen again. And we'll make that award sufficient so that they understand it is not just going to be a slap on the hand. It's going to be something significant to let them know we will not tolerate this again. And we will ask for the one thing that you can do as members of the jury. And the one thing that you can do is to render justice. And we will ask you to do that and to award a very substantial amount of money, to award the one thing that you can, and that is 100% justice. Thank you. All right, so that's an opening statement in this case. And these are actual documents from this case. But I want you to understand how dangerous this is, because when you think about it, this product has actually been banned and suspended in other countries, not in the United States. So if you take a look at the FDA safety warnings on this, and some of you, I'm sure, are aware of these FDA safety warnings, well, take a look at what happened in 2014. The device was now classified as moderate risk, but in 2016 it's classified as high risk. And in fact, there had been so many complaints throughout the world, not just in the United States, that various countries have decided time to suspend this product because the product itself is unsafe. I wanted you to see what happened in court so that you can get a view, a glimpse from that abbreviated opening statement, so that you could see what really was going on and why it has been so offensive to actually produce a product when you knew that there were dangers and you didn't share it with the doctors. How about worldwide? I recognize this doesn't come clear, but really what's highlighted in the yellow, if you can see it, it actually reads ban, and they banned the use, so that New Zealand was one of the first countries to ban the use of this product. But other countries have banned the product or suspended the product. And in fact, as recently as July of this year, last month, Wales, Northern Ireland suspended the use of mesh. Southern Ireland suspended the use of mesh. NHS England suspended the use of mesh. This product has been dangerous, and this is what's been going on. But I wanted you to actually understand what was happening. Because if you think about it, the company was actually blaming the doctors for the injuries to the plaintiffs. And there's a reason for that. And this is something you need to know about. The learned intermediary doctrine. This is in the United States only. For those of you who are outside of the United States, you don't need to know this as much. But for those of you who practice in the United States, this is a scary doctrine for you. And what it does is it actually foists blame not on the company, but right on the doctor. Because what it's saying is you as the doctors, you have to advise your patients. We as the company, we don't have any obligation to do that. We have to tell the doctors. And because of that, if in fact you don't provide appropriate informed consent, the one who's at fault is you, not the company, with one exception though. And that one exception is something that we look for. And I'm going to tell you why we look for it. I'm not going to hold back in this case. We look for this exception to show that there was fraud or that there was inappropriate warnings or that the company had information that they didn't provide to the doctors, because then you could hurdle the learned intermediary doctrine, the doctor being the intermediary. And if you think about it, the reason we do this is why? Why would plaintiffs' lawyers want to bring a company in, not just the doctors? The answer is pretty clear, right? The deep pocket. So if we're looking for that to actually protect our patients, to make sure, our clients rather, to make sure that they are compensated fully and fairly, this is what we're doing. But this learned intermediary doctrine is something you need to know about. And this is a doctrine that actually developed many, many years ago in the United States, back in the 30s, 40s, 50s, where doctors actually made house calls, and the patients had to rely on the doctors to provide information to them, because it was the doctor who actually gave the patient the information, not the company. But now, if you think about it, this is actually an antiquated doctrine. And I actually think it hurts doctors terribly. It hurts surgeons. Because what's the first thing that patients do when they know that there's going to be a product that's going to be inserted in them, or a doctor's going to use a product? They'll get on Google. They'll check it out. They'll see what's going on now. And they'll make sure that they have a way of understanding what the product is. Well, that flies in the face of the learned intermediary doctrine, saying the only way they can get information is through the doctor himself or herself. Well, it's got to change at some point. The law has to catch up with this. But who doesn't want the law changed? The big product manufacturers. And then you get into the political arena. And this is something that should concern you as well. But I want you to be aware of this because it is dangerous for doctors, where the companies can actually be off the hook on a motion for summary judgment, it's called, blaming the doctors for failing to inform the patient, not the company. So let's talk about informed consent for a little while. When we think about informed consent, what do you have to do as a physician? Well, as a physician, you actually have to provide your patient with sufficient information to counsel them appropriately as to the risks, the benefits, and the alternatives to the surgery that you're going to be performing. If you do it appropriately, fine. But I recognize that there is a tension. And the tension that's there is the tension between telling the patient too much and scaring the patient, or advising the patient appropriately on the other hand, and letting the patient make an appropriate decision. You don't give consent. The patient gives you the consent to perform the surgery. So what I thought I'd do is I'd actually show you a little bit more of what goes on in court, since you don't get to see this too often. And Roger has graciously agreed to be the witness in this case. So let's assume I'm questioning Roger Tomkowski about informed consent. I want you to see the way that this would work, because obviously if I'm going to be questioning him, I'm going to try and set him up first before I knock him down, so you can see the way the cross-examination works. Doctor, can we agree that your most important concern is the health of your patient?
Of course.
Certainly the safety and well-being of your patient is important to you as well?
Yes.
One of the things that you've done, correct me if I'm wrong, is you teach, don't you?
Yes.
You teach residents?
Yes.
Medical students?
Yes.
Fellows?
Yes.
And you tell them the very same thing, that the most important concern is the safety and health of the patient, true?
Yes.
To the extent that that wasn't their most important concern, you wouldn't tolerate it, would you?
Correct.
In fact, one of the things that you do is you explain to them that before any procedure takes place, the patient has to be informed of what the procedure is, true?
Correct.
So you tell them you must inform the patient carefully, true?
Yes.
After all, it's not just a checklist that you have the patient sign, right?
Correct.
That would be inappropriate, wouldn't it?
Yes.
If you just had the patient sign a checklist without really going into details, that would be a departure from accepted standards of medical care, wouldn't it?
Yes.
Certainly something you would never allow your residents to do, correct?
Correct.
So one of the things that you do is, before you ever perform a procedure involving mesh, you certainly educate yourself about it, true?
Yes.
Certainly read the package inserts, correct?
Yes.
Certainly know what the information is as far as what could harm the patient, true?
Yes.
And you would never want to harm the patient, true?
Correct.
So you give the patient sufficient information to make a decision, correct?
Yes.
Doctor, can we agree that you're certainly aware of the FDA warnings with respect to mesh?
Yes.
You are aware that it's classified now as a high-risk product?
Yes.
I noticed in the informed consent form that you have, the FDA warnings are not even listed. True? Take your time, doctor.
I thought they were.
Well, doctor, did you say that it's now classified as high risk? Did you tell your patient that?
No.
In other words, you knew it, but you chose not to tell the patient that it was high risk. True?
Correct.
And that's what you believe is appropriate to teach your residents, right?
No.
So it's something that isn't appropriate, yet you didn't tell them, correct? Take your time.
Can I have a sidebar?
All right. Look, I just want you to see what's going on. Because what's going to happen is the plaintiff's lawyer is going to try and reach for everything that's out there. And the plaintiff's lawyer is going to reach, but remember, I mentioned there's a tension. It doesn't have to be written. I want you to know this. You don't have to write that the FDA has warned. What you have to do is you have to inform the patient sufficiently. And if you do inform the patient sufficiently, as long as you could point to something that you actually have in writing that you did inform the patient of these various risks, you'll be okay. But the plaintiff's lawyer is going to continue to reach as far as they can to show that, in fact, something was done that they believe to be inappropriate, and then it's going to be a question of fact for the jury to make the determination. The way the plaintiff's lawyers, those that really know what they're doing in this field, set it up is, can we agree at all times, doctor, good counseling is important? True?
Yes.
In fact, to the extent that you don't provide good counseling, you would never tolerate that from a resident, true?
Yes.
And certainly you practice what you preach, true?
Yes.
So you tell the patients, for example, that there might be, with this product, pain with sexual intercourse, true?
Yes.
You tell them that they might have difficulty in removing the product in the event things go south, correct?
Yes.
And to the extent you didn't tell them that, that would be inappropriate, correct?
Correct.
Here's what I'm doing with this, because one of the things that happens is, a lot of times you won't catch someone in, for example, a failure to tell, like I just showed you a moment ago, but what will happen is there's a question of fact as to whether or not the doctor actually did say this, if it's not written, and then you have a contest. I don't want to say pissing contest since I'm here, but you have a contest between the doctor and the patient. And the question is, who are they going to believe? So the question really is, have we provided sufficient informed consent? And if you do, all you really have to do is advise of the reasonable risks, the benefits, and the alternatives. But I want you to know what's going to happen because of this learned intermediary doctrine is the company is going to say, we have no obligation to tell the patient. In fact, we'll be off the hook because of the learned intermediary doctrine in the United States. But in fact, the doctor, it rests squarely on your shoes. You must tell the patient about the reasonable risks, benefits, and alternatives. Okay? All right. I think I probably used up enough of my time. I want to thank you all for allowing me to speak here this morning. It's been a pleasure.